So the FBI raid on Cohen is in the news, and my boy Sticks here decided he wanted to talk about it. And once again, he shows us why he doesn't understand the law. He may understand politics, he may have a grip on the political leanings of the nation, but he doesn't understand the law. So let's find out how and where he went wrong.
All right, everyone. The FBI has raided Trump's former lawyer, Cohen, of course. His home and office were both raided the other day, and emails were obtained, other confidential documents. Trump, very rightly, this goes beyond the political into the realm of the constitutional, so it has nothing to do specifically with the investigation into Trump on that end. There's such a thing, and Trump is correct, as attorney-client privilege. Mueller has far exceeded his bounds. The norm of how such a process operates is fundamentally violated when you have obtained a bunch of now supposedly confidential records, constitutionally protected under our legal.
Okay. So he makes this claim that attorney-client privilege is constitutionally based. And he links to this archive.is link, which is Business Insider. Business Insider makes the claim that communications between clients and their lawyers are often beyond the reach of law enforcement based on attorney-client privilege. This is a correct statement, but then they say it's derived from the U.S. Constitution. When you click this link, you come here to, this is a Second Circuit decision. It's an appellate decision from 1973. And the closest thing we have to it, so the claim in this is that the lawyer claimed that it was a violation of the appellant's Sixth Amendment right to privacy of communication with his counsel. That isn't a attorney-client privilege claim, so I don't know exactly how they're tying to it, but whatever, we'll play along. And so appellant asserts that participation of these individuals in strategy conferences with Rosner's lawyers violated his Sixth Amendment right to freely consult his counsel without government intrusion. We do not lightly regard so serious a constitutional claim, for the essence of the Sixth Amendment is indeed the right of, or is indeed the privacy of communication with counsel. So this doesn't say that it is attorney-client privilege. They don't state that attorney-client privilege is based on the Sixth Amendment. This is U.S. v. Zolan. This is from 1989. This is significantly after this case, which was 73. So this is Zolan. And Zolan holds questions of privilege that arise in the course of the adjudication of federal rights are governed by principles of common laws, may be interpreted by the courts of the United States in light of reason and experience. Federal Rule of Evidence 501, we have recognized the attorney-client privilege under federal law as the oldest of the privileges for confidential communications known to the common law. Although the underlying rationale for the privilege has changed over time, courts long have viewed its central concern as one to encourage full and frank communication between attorneys and their clients, and thereby promote broader public interests in the observance of law and administration of justice. The purpose, of course, requires that clients be free to make full disclosure to their attorneys of past wrongdoings, in order the client may obtain the aid of persons having knowledge of the law and skill in its practice. In fact, if we go to Rule 501, privilege in general, the common law, see those words there, the common law as interpreted by the United States courts in the light of reason and experience governs the claim of privilege unless any of the following provides otherwise: United States Constitution, federal statute, or rules prescribed by the federal court. But in a civil case, state law governs privilege regarding claim or defense for which state law supplies the rule of decision. Now these are the committee notes. Article 5, this is Article 5, privileges. Article 5, as submitted to Congress, contained 13 rules. 9 of those rules define specific non-constitutional privileges which the federal courts must recognize, i.e., required reports, lawyer-client, psychotherapist-patient, husband-wife, communications to clergyman, political vote, trade secrets, secrets of state, and other official information, and identity of the informer. So, non-constitutional. It's not a constitutional-based right. And in fact, you can see from like California's rules of evidence, there's a lawyer-client privilege. So I don't know why they're saying it is a constitutional right, but there is an exception to lawyer-client privilege. As we go on to read, we're back in Zolan. The attorney-client privilege is not without its costs, since the privilege has the effect of withholding relevant information from the fact finder. It applies only where necessary to achieve its purpose. And remember, its purpose was to allow the client to talk to the lawyer and to get full, fair, and accurate legal advice. The attorney-client privilege must necessarily protect the confidences of wrongdoers, but the reason for that protection, the centrality of open client and attorney communications to the proper functioning of our adversary system of justice, ceases to operate at a certain point, namely, where the desired advice refers not to prior wrongdoing, but future wrongdoing. It is the purpose of the crime-fraud exception to the attorney-client privilege to assure that the seal of secrecy between lawyers and client does not extend to communications made for the purpose of getting advice for the commission of a fraud or crime. There's no federal rule that codifies that. There's no federal rule of evidence, or at least that I'm aware of, that codifies that. I've only seen case law. California, however, has. This is the lawyer-client privilege. There's no privilege under this article if the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit a crime or fraud. Now, I don't know if he said it thus far. I don't think he has. So we'll wait to hear what he says about jurisdiction.
System, and you're apparently digging through them. But I can tell you why Mueller's doing this. I can tell you exactly what this is. This is an open admission that Mueller's got bullshit. He's got jack shit on Trump. He is now seeking to exonerate himself from having to come out and tell the American people, yeah, we did it. Now, after more than a year and millions of dollars, we've determined that Paul Manafort, Tony Podesta, and some of these other people laundered money. We determined that some Russians made Facebook posts. How does the Stormy Daniels thing, by the way, even have anything to do with the Mueller probe? The Mueller probe.
I just want to point out that getting a warrant doesn't mean that you have nothing. In order to get a warrant, you need probable cause. Probable cause is a showing of proof that it's more likely than not that there is evidence of a crime as stated in the warrant, or if it's an arrest warrant, it's more likely than not the person committed a crime. It's not reasonable suspicion. It's a higher burden of proof. So he just said he doesn't even understand.
Was started to look into the possibility of collusion between members of the Trump campaign and a foreign state. It has since then morphed into both a money laundering investigation and an investigation into a payment made by Trump's former lawyer to an escort, essentially. What the hell does that have to do with anything? We're talking about cases that are years old, sometimes don't even involve Donald Trump.
Well, the reason that this is going on is because of jurisdiction. The jurisdiction of a special counsel shall be established by the Attorney General. In this case, since the Attorney General, Jeff Sessions, recused himself, it's up to the Deputy Attorney General, which is Rosenstein. I think Rosenstein or Rosenthal, I forget. The special counsel will be provided with a specific factual statement of the matter to be investigated. But then there's also additional jurisdiction. If in the course of his or her investigation, the special counsel concludes that additional jurisdiction beyond that specified in his or her original jurisdiction is necessary in order to fully investigate and resolve the matters assigned, or to investigate new matters that come to light in the course of his or her investigation, he or she shall consult with the, in this case, Deputy Attorney General, because, again, Sessions recused himself, who will determine whether to include the additional matters within the special counsel's jurisdiction or assign them elsewhere. Well, in this case, it seems as though Rosenstein, whatever his name was, assigned it to Mueller. That's how he's getting it.
And you've got attorney-client privilege to worry about. It is strange to me how many people don't have a problem with this. It violates the Constitution. Trump.
It doesn't violate the Constitution.
Has the right to confide in his legal representative. The fact that the communications are being stored by a former lawyer instead of his current lawyer, what the hell does that have to do with it? Oh, so they magically...
attorney-client privilege doesn't end at the end of your representation. It persists. It persists past the death of the client. I believe you can divulge some things to like the client's estate, but I mean, I'd have to go over the ethics rules in order to figure out exactly what you could say. Generally speaking, though, don't say a word to anybody about what your client told you ever if you're a lawyer, if you could possibly help it. It's always better safe than sorry.
Stop being confidential when he changes lawyers. I'm not 100% sure that that's how it works. No, you know, the way an investigation is supposed to work is, hey, I have a reasonable suspicion of wrongdoing in some case. I've applied for and obtained a warrant. A counsel has been convened for a special investigation.
Okay, so we know from the Fourth Amendment that it takes no warrants shall issue but upon probable cause, not reasonable suspicion. So they have a warrant. They've gotten that from a magistrate or a judge of some sort. And they have shown that judge enough evidence that that judge believes that there is probable cause that a search of Cohen's property will turn up evidence of crime. Now, why did they do this instead of doing a subpoena of Cohen? I don't know. But if you look, Cohen is being investigated for possible bank fraud. Cohen is being investigated. So this whole thing of the attorney-client privilege, I have no idea why. Like, if you went past your business insider of Trump's tweets and terrible legal advice or whatever, it's Cohen is being investigated. Cohen can't assert attorney-client privilege for his own crimes. It won't work. Cohen is being investigated. I'm not saying that Cohen did anything wrong. I don't know. But Cohen is being investigated. And without being able to look at the warrant, which I don't believe they've released, who knows? Now, the way it will probably work, and I could be wrong on this, but typically there is going to be like a committee of people reading these emails and documents and things that they've seized from Cohen to make sure that that nothing violates attorney-client privilege or anything like that, so that the prosecution won't be tainted by it. Bad things tend to happen if the prosecution sees documents they shouldn't see. All of a sudden they have to prove they didn't rely on it, and good luck with that. And if they can't meet the required proof showing that they didn't rely on it, then all of a sudden everybody who saw the document has to be excluded from the prosecution. I mean, it just goes real bad real fast. Now, as far as the Sixth Amendment, which this was talking about, there is some interesting things about it. Now, the first thing that you should know is that the Sixth Amendment only attaches at critical stages of the prosecution. Everybody's familiar with Miranda v. Arizona. That's custodial interrogation. If you're arrested or if you're taken down to the police station in something that looks like you're arrested, then that's custodial interrogation. Miranda applies. You know, you have the right to an attorney. You have the right to remain silent. You have the right to an attorney. That's where the Sixth Amendment is attaching. Post-indictment lineups. That's Kirby v. Illinois. If you're going to be put into a lineup and a witness is going to pick you out of a lineup, your attorney has the right to be there to observe what's going on, to make sure that there's nothing screwy with it. Preliminary hearings, that's Coleman v. Alabama. You have the right to an attorney at preliminary hearings. arraignments. That's Hamilton. I want to say Hamilton v. Alabama. But is Coleman v. Alabama? I think it's Hamilton v. Alabama. Felony trials. That's Gideon v. Wainwright. Very, very famous case. And then sentencing. That's mempa. Mempa v. rhay. I'm probably wrong on that. And then appeals as a matter of right. That's Douglas v. California. So it only attaches at very specific stages. And it only attaches. I know this is going to sound stupid and everybody thinks that I'm retarded. Every non-lawyer thinks I'm retarded when I say this, but it only attaches if you've been sentenced to any time incarcerated, in jail or in prison. Anytime. So once you've been sentenced to even 1 day in jail, retroactively, you should have had a lawyer. So if you were denied a lawyer and then you get time in jail, all of a sudden that right to a lawyer attaches and basically you get a whole new trial. Now, what is my evidence for that? This is Arsinger v. Hamilton. This is a Supreme Court case, U.S. Supreme Court case from 1972. We hold that, therefore, absent a knowing and intelligent waiver, because you can always, no, not always, you can generally waive your right to an attorney. No person may be imprisoned for any offense, whether classified as petty, misdemeanor, or felony, unless he was represented by counsel at his trial. Now you're like, well, what about in cases where the possible fine is like $1,000 or 6 months in jail? You know, if you get the $1,000, then you didn't have to have an attorney. They didn't have to give you an attorney. But if you got 6 months in jail, then all of a sudden, how does that work? Well, the court addresses that. Under the rule that we announced today, every judge will know when a trial of a misdemeanor starts that no imprisonment may be imposed, even though local law permits it, unless the accused is represented by counsel. He will have a measure of the seriousness and gravity of the offense and therefore know when to name a lawyer to represent the accused before trial starts. So like I said, if they don't have a lawyer and they're sentenced to even 1 day in jail, all of a sudden everything goes back. Now, if you contrast that to your right to a jury attaches if you're facing a potential incarceration of more than 6 months. This is Duncan v. Louisiana, Supreme Court case from 1968. In this case, they're talking about in determining whether the length of the authorized prison term or seriousness of other punishment is enough to itself require a jury trial. We're counseled by blah to refer to objective criteria, chiefly the existing laws and practices of the nation. In the federal system, petty offenses are defined as those punishable by no more than 6 months in prison and a $500 fine. In 49 of the 50 states, crimes subject to trial without a jury, which occasionally includes simple battery, are punishable by no more than 1 year in jail. Moreover, in the late 18th century in America, crimes triable without a jury were for the most part punishable by no more than a 6-month prison term, although there appear to have been exceptions to this rule. We need not, however, settle in this case the exact location of the line between petty offenses and serious crimes. It is sufficient for our purposes to hold that a crime punishable by 2 years in prison is, based on past and contemporary standards in this country, a serious crime and not a petty offense. Consequently, the appellant was entitled to jury trial, and it was error to deny it. If you go by the bar, by the multi-state bar exam, and what they'll teach you in law school is that if you're looking at more than 6 months, you get a jury. That's where we're at. And then finally, this is Weatherford v. Bursey, another U.S. Supreme Court case from 1977. This is looking at how it's kind of similar, the Sixth Amendment to the attorney-client privilege. In this case, they're looking at a Sixth Amendment case where a informant or I think a secret agent, yeah, not a secret. What do they call those? Undercover agent was invited to sit in on the defense's counsel's kind of planning sessions, and the holding. But just to draw from it, even though there was a agent basically of the prosecution in there, the court found that there being no tainted evidence in this case, no communication of defense strategy to the prosecution, and no purposeful intrusion by Weatherford, there was no violation of the Sixth Amendment insofar as it's applicable to the states by virtue of the 14th Amendment. Proof in this case fell short of a 1983 claim, blah, blah, blah. But what you're going to notice on this is that it's not attorney-client privilege that was implicated. And the reason why it wasn't attorney-client privilege was because this was at a critical stage of a trial. They were actually planning for the felony trial. There was a trial going on, and the undercover agent sat in on. He was invited to sit in. That's important. But he sat in on these strategy meetings between the defendant and his lawyer. So that's different than in this case. If Trump was in the stages at one of the critical stages of a federal prosecution, of a prosecution in general, I should say. Then his lawyer who's representing him in that he'd have a Sixth Amendment right to to keep the prosecution out of it. So like if Mueller was trying to tap Trump's conversations with his defense attorney, that would be a Sixth Amendment violation. But we're not in one of those critical stages of trial, so it's completely divorced from the Constitution. So I hope I made it clear. All these notes, I'll figure out those cases for the critical stages where it attaches. I do know I'm 100% on it's custodial interrogation, it's post-indictment lineups, it's preliminary hearings, it's arraignments, it's felony trials, it's sentencing, and it's appeals as a matter of right. There was some in there that I wasn't quite sure of the names of them, but I'll find those and I'll put them in the notes. Anyway, I hope you found this informative and fun. I do this because I actually love the law and I like talking about it, and it's kind of annoying when with big names. I mean, this dude's got 223,000 people who listen to him. He's got 30,000 views. And he's telling people wrong stuff, and I think that's sad. So that's what I'm doing, is I'm just trying to correct the record. And no offense to Sticks or anybody who likes Sticks or Trump or anybody who likes Trump or Cohen or Mueller or whoever. That's just the law as it is, and I hope you enjoyed it and learned something. Have a great day.